Dokie. We are letting everyone get settled in before we get started, but just give us a couple more seconds for everybody to get admitted to the room and we will get to rolling with things. Thank you so much for being here, everybody, on this wintry day here in Nashville. Hopefully you're at home, safe and sound, and you're able to look out your windows and just enjoy one. My name is Stephanie Williams, and on behalf of the Women's Political Collaborative, I welcome you to this Lunch and Learn with the Probate Courts. We're so very excited to present this opportunity to you today. If you're unfamiliar with the Women's Political Collaborative, we have really embraced the ability to go virtual over the past year and have stepped up our programming to have monthly informative events consistently. And we have dealt with things concerning the courts and issues of great importance here in the community. We had the opportunity to talk to, I always say judge, but that's incorrect, Chief Drake of the Metro Nashville Police Department, and a couple of weeks ago. And so we've just been doing we've had a really fun time doing these events. We're thankful that you are here to join us. If you would like to become a member of the Women's Political Collaborative to support our ongoing efforts for what we do in the community and what we do on the Hill, please feel free to go to our website at wpctn.com and probate courts. And in a moment, we'll get started with that. But I do want to inform you of our Black History events that we have going on this month. On February the 23rd, our book club, which we've had going for about a year now, which is a lot of fun. We're going to be in partnership with Leadership Middle Tennessee, and we're going to feature Alice Randall in her book, Black Bottom Saints. So that'll be on February the 23rd. That's a Tuesday evening at 6 o'clock. We invite you to join us for that. And then on Friday, February the 26th, we will have another Lunch and Learn where we speak with Herman Hicks, the CEO of the National Museum of African American Music, along with Board Vice Chair Stacey Garrett, and it's going to be moderated by Board Chair Kevin Lavender. If you have been unable to go to the museum so far, it is a very inviting experience that everyone should go and learn and enjoy. It's very enlightening, and they've got a lot of good immersive experiences there that you will enjoy also. So definitely take the opportunity to support that new treasure in Nashville now, and tune in to us on the 26th to learn a little bit more about that. Having said that, I want to go ahead and get started into our programming for today. Our program today is going to be moderated by Barbara Moss. And Barbara is the founder of Elder Law Nashville PLC and has been practicing law in Nashville for over 30 years. She focuses her practice on elder law, conservatorships, probate, estate planning, Medicare, and Medicaid, which is always two things I always get confused about. So hopefully I'll learn a little bit about that today. I always use those interchangeably, and I know they're not. She's been recognized for her contributions to the law profession in the community with numerous honors, including the Athena Award in 2007. And she's been named Best of the Bar, one of 70 best lawyers in Nashville, multiple times by her peers in Nashville, and most recently in 2020. She's also been chosen as a Mid-South super lawyer in elder law by Law and Politics magazine from 2006 to present. And Barbara also serves as an adjunct professor at Vanderbilt School in elder law, and an adjunct professor, at Vanderbilt Law School for 20 years. And she also teaches elder law at the National School of Law. She's written more than 85 columns for the Tennessean, and most recently under the topic Advice for Seniors. So we're very fortunate to have her with us today. There is no one else that would be more fitted to moderate this event. And Barbara, thank you so much for being here.
Well, thank you, and welcome everybody to this program. We have three great speakers today. So this program, Probate Court, Protecting the Most Vulnerable. I'm going to introduce the speakers, and then I'm going to let them take over. And everybody put your questions into the chat box, and after they finish whatever presentations they want to make, I'll read them the questions. So I'm going to introduce first Judge David Randall Kennedy. He's been a circuit court judge since 2003. Before that, he was in private practice in the firm of Kennedy and Brown and was on the Metro Nashville Council for 2 terms. He attended the Nashville School of Law, Middle Tennessee State University. He's received the Long Rifle Award from the Middle Tennessee Boy Scout Council, the Volunteer Award from Senior Citizens, the New Club Builder Award by the Donaldson Hermitage Exchange Club, and he was selected Vice President of Tennessee Trial Lawyers Association. So thank you, Judge Kennedy, for joining us.
I'm glad to be here. Thank you so much, Barbara.
Let me go ahead and introduce everybody, then I'll turn it over to you, Judge. Amy Bryant is the Director of the Office of Conservatorship Management. She, prior to that role, she served as a senior attorney for the Division of TennCare, where she supervised a staff of 25 and was responsible for creating training materials, giving presentations, and helping to develop a resource bank for the Administrative Appeals Unit. Prior to working for the state, Amy worked in private practice on a variety of legal matters. She plans continuing education for the Napier-Luby Bar Association, and she served in numerous leadership positions. And our third panelist is Michelle Potts, as opposed to Barbara Moss. And Michelle is a solo practitioner in Nashville, offering services in elder law and probate matters, including estate administration, conservatorships, guardianships, and trusts. She also represents clients in Social Security disability matters and is a Veterans Administration accredited attorney. She's been licensed to practice law since 1998, admitted in all Tennessee courts, and is a Rule 31 General Civil Mediator. She won the Tennessee Attorneys for Justice Pro Bono Service Award and has served in a number of leadership positions, including with the Conservatorship Association of Tennessee, and is currently co-chair of the Nashville Bar Association Probate Committee. So thank you, all of our distinguished panelists, and I'll turn it over to Judge Kennedy.
Thank you, Barbara. It's a pleasure to have an opportunity to be with you today, and likewise with my co-panelists, Amy Bryant and Michelle Potts. I've had the opportunity to work, obviously, extensively with you, Barbara, in litigation where you've appeared before me and the Seventh Circuit Court or the Probate Court of Davidson County, Tennessee. And certainly, I think Stephanie hit it on the head that you are a premier attorney in our city, and I'm delighted to have you serve as our host. Likewise, I see Michelle Potts in court frequently, and Amy Bryant is the director of probably one of the most important organizations that has ever been created to serve a probate court anywhere in Tennessee. And partly that's because it's the only one of its kind in this or the southeastern United States. So I know our folks that are joining us today will benefit greatly from hearing what both Amy and Michelle have to say. You know, one of the things that I was asked to take a look at when Joyce McDaniel and the folks at this organization asked me to appear was things that deal with our most vulnerable citizens. And let me just define for you who I perceive to be among our most vulnerable citizens. And I really put them in 3 categories. One are the severely disabled adults whose disabilities are significant enough that they are unable to either care for themselves completely independently or who need some assistance, great or small. The second group are simply senior citizens who, due to age and physical infirmity or other infirmities that are a natural progression of their aging process, have made them vulnerable to folks that might want to exploit them or take advantage of them. And then the third category that I wanted to deal with today, and maybe there may actually be 4, but the third one that comes to my mind most frequently are children who have been under guardianships who also have either either birth defect or congenital defects, or have been part of a traumatic injury, who age out from being a minor, who now need to have a conservator. And so those three categories are by no means the only folks that we deal with. There's also a huge homeless population, many of whom are veterans, others of whom have dual diagnoses, drug addiction and otherwise, that really require court intervention. So looking at those, I thought, man, we've got a huge set of our population that are burdened with these challenges. And the good news is we've got a great bar. We have certainly a huge number of attorneys in Nashville who are willing to step up and serve as guardians ad litems, as attorneys ad litems, and who are now serving on a panel, an independent panel, serving as conservators and guardians for those folks who may not have someone else more qualified. Now, I don't want to dominate the conversation. I don't intend to do that, but I do want to say this. Many of you are aware that we are now handling the largest volume of conservatorship cases of any court in Tennessee. We have, I believe, and Miss Bobbitt, Miss Amy Bryant could probably voice more specifically the numbers we've got, but we have several thousand open cases in Davidson County, in Nashville. And so they run the gamut, and we could talk about any individual fact situation you might want to talk about here today. Obviously, I got to be a little cautious about what I say about open cases because those open cases are still pending. And in conservatorship law, one of the distinctions between conservatorships and other types of litigation is that frequently when you establish a conservatorship, that's really just the beginning of court oversight. And so conservatorship may begin when some young adult is 19 or 20 years old, and it may extend throughout the lifetime of the respondent if their disability is a lifelong disability. So it's an interesting area of the law. It's a challenging area of the law. I feel very honored and privileged to have the opportunity to serve as the judge who handles the vast majority of these cases. And so I'm here today to answer any questions I can that you may have of me. And with that, I'm going to kind of segue over, if I can, to Michelle and Amy. I'm not sure which of them wants to go first, but I'm here to answer your questions and maybe supplement what Amy and Michelle may say about their view of the conservatorship laws and what it says about vulnerable people. Now, I got to mention one thing, though, ironically. When I was first asked about this subject matter, I had just taken a case under advisement, and I don't want to get into the specifics of the case other than to say this. The respondent in the case was in his late 90s, and the subject of this controversy was induced to enter into a reverse mortgage. And if any of you have been in my courtroom, you know that that I don't get real happy when I hear about reverse mortgages that elderly disabled people get into. That's an example, just the fact situation, an example of where elderly people are subject to financial exploitation. Doesn't mean people should never get a reverse mortgage, by the way. Just thought I'd mention that one. I've got a file that I'm looking at right now that involves exactly that kind of a situation. And I've seen more of that now than I've ever seen historically since I've been on the bench. It's a growth area, sadly, that we're going to have to look at as time goes on. So with that, Barbara, if I can, I'm going to hand the baton over. I guess we'll go, should we go to Michelle first and then to Amy, or to Amy first and then Michelle? I'm going to see which one of them speaks up, I guess. How about that?
I'll go first, Judge.
There you go.
Good afternoon, everyone, and thanks, Barbara. I'm Amy Bryant. I'm the Director for the Office of Conservatorship Management. And for those of you who do not know what the Office of Conservatorship Management is, we are a second level of oversight for conservatorships in Davidson County. And as Judge Kennedy mentioned, we have about 2,400 conservatorships that are open currently in Davidson County. In our office, we do welfare checks for people under conservatorship, and that's done on a random basis or by credible informant. And we also do financial reviews for every case that has accounting due in Davidson County. In addition to that, we have training for individuals that either want to become conservators or who are already conservators. That training can be found on the OCM's website. We also provide resources, and we will file pleadings to remove a conservator if they're failing to fulfill their fiduciary duties. I would imagine that everybody on this call may know what a conservatorship is, but many times when I speak, people will ask what a conservatorship is. And a conservatorship is a statutory construct that allows one individual to make decisions based on an order from the court for another adult individual. Conservatorships are only for adults, and they're not for anyone under the age of 18. And our office, if an individual, some of the things that our office deals with are cases where an individual feels they no longer need a conservatorship. In that regard, they'll call our office and we will talk to them and their conservator. If necessary, we'll file a report with the court so that the court is aware that they now need a review of their disability. Many times we will have individuals call that lets us know they can no longer fulfill their fiduciary duties. And then our office will either seek to fill that void by making a recommendation to the court or alert the court through report that that individual needs a new conservator. Or if the conservator passes away, our office will assist the court in helping to either find another family member that can be a conservator for that individual, or let the court know that they may possibly have to use the independent conservator panel for that. The independent conservator panel is a group of lawyers, non-lawyers, and organizations that take on conservatorships in Davidson County for individuals that don't have family or friends who are able to take on that responsibility. If you're interested in getting on the independent conservator panel, you can contact my office and we will give you information on that. You'll be required to take the training that was put together by the Office of Conservatorship Management, and then answer questions that Judge Kennedy has and that our office has to determine if you are eligible to be a conservator in Davidson County. I welcome all questions about conservatorships if you all have any, and I'll turn it over to Michelle.
Thank you, Amy. I assume everyone on this call as well understands what a conservatorship is, but I think it can be confusing because other states refer to a proceeding such as a conservatorship in Tennessee over an adult as a guardian. So sometimes you hear that word used interchangeably. It gets a little more complicated if a case is filed under Title 71 by Adult Protective Services, because oftentimes those appointments are called a temporary guardian. But generally in Tennessee, a guardianship is to protect a minor, a person who's under 18. That may be over their person and property or both. You see that come into play a lot, perhaps when a couple is divorced and one parent dies and leaves life insurance or inheritance to the child. In those situations, there's generally a guardianship over the property that is filed to protect the minor's property. And in those situations, many times that money is paid into the registry of the court. That's a good way to protect the money, cut down on cost, and avoid the expense of bond. I think a lot of you know I represent the public guardianship program for the elderly in the Middle District. That client provides services for individuals who are 60 or over, who don't have any other person that can serve as their conservator, and they don't have funds generally to pay for a conservator. In certain circumstances now, the public guardianship program can accept a client under 60 if there's a finding by the Court of Disability that there's no one available to serve, and it is approved by the Tennessee Commissioner on Aging. I also want to let people know there are 8 other public guardianship programs in Tennessee. So there's a public guardian in every county, regardless of where you may practice or live. Amy's got a great website. There are great resources. One of the things I've been doing now before I agree to represent someone as conservator is I'm sending them to Amy's website. I'm asking them to take her training. I also send them to the Davidson County Clerk's website under the probate section, and I have the client read the fiduciary instructions before I agree to represent them. You've probably seen Judge Kennedy go over those in court. He generally goes over those at the beginning of the docket, or at least he did when we were in real live court, and, you know, explain to litigants, you know, here's your responsibility. Here are your duties. Here's what you have to do. Here's the oversight the court has in place for you. There are lots of other organizations that serve as conservator in a professional capacity. There's 50 Forward, there's ComCare, there's Guardianship and Trust. There are other resources available in Tennessee. The Tennessee Conservatorship Association has a good website. It has training. There's the National Guardianship Association. So if you want further information, I would encourage you to look at those websites as well. I am co-chair of the Nashville Bar Association. We had some interest last week. I don't know if any of you have seen the Britney Spears documentary, but that has kind of brought conservatorships to the forefront in the last week or so. So I just kind of want to mention that to everybody. If you're interested in conservatorships, that might be something you want to take a look at. I don't have any personal opinion about it. It was brought to the NBA's attention, and it was suggested we might want to look at some sort of CLE. Barbara, that might be something you want to get, you know, involved with. But those were kind of the main things I wanted to go over. And the other thing I wanted to touch on is I have become much more conservative about asking for bond in cases. I don't really ask for it to be waived on a lot of my cases now. I used to, even if I'm drafting a will now, I will usually discuss with the family, you know, what bond means, that it's certainly a safety measure. And I'm sure Judge Kennedy may want to talk a little bit further about bond. I know that's something that's really come up a lot in a lot of our cases. So thank you, Barbara, for having me here. I welcome any questions.
Judge Kennedy, would you like to talk about bonds? There's
Yeah, let me address two points that were brought up by one by Amy and one by Michelle in particular, both of them on the bond issue addressed by Michelle. You know, initially in our court, we have taken the position that we could exercise our discretion and waive bond if the amount of the assets being maintained for the respondent were nominal. And let me say this to you. You know, conservatorships are not something that only affects the wealthy or only affects the poor or the working middle class. It affects people from all economic strata and from all walks of life. But historically, we have said, well, you know, if you got only Social Security income and it's maybe under $10,000 a year, and your annualized income is your only asset, or you have no income and your personal property assets are under $10,000 or your little bank account's under $10,000, we would historically waive the bond and still frequently do that. However, there are cases that have happened over the course of these many years in every court, I think, in Tennessee, and certainly more celebrated in Nashville because of the number of folks we have here who are quote unquote wealthy or who have large assets, where a conservator has been appointed and even with a bond has either pilfered, stolen, or misappropriated money. And so the bond, what the bond is for is to ensure, I used to say in open court, is to ensure that the conservator doesn't run off to Las Vegas and blow all the money or take it and get on a worldwide cruise and spend it on his girlfriend or her boyfriend. So bonding is a fidelity or a surety matter. It's not like the bond when you get out of jail where you get bonded out. It's an insurance policy to ensure that if the money cannot be accounted for, and if it's as a result of the malfeasance or misfeasance or wrongdoing, or even negligence of the conservator, that we'll have some money to put in place to reduce or mitigate the damages that result. So the bond issue is a big deal. Now, no question about it. And you may know I have a probate master, Elizabeth Johnson, and Ms. Johnson has bond reviews literally every Wednesday. in our court system, doing them all virtually right now as a result of the pandemic. Now, Amy's program, let me mention it real quickly. She didn't brag on herself, but I'm gonna brag on her a little bit. When we appoint a guardian ad litem in a case, the guardian ad litem is known as, by the courts, as the eyes and ears of the court. And the guardian ad litem goes out and investigates the fitness of the conservator, the disability of the respondent, the assets that are there, and the family dynamics, among other things. But Amy in her position as director of OCM is like having a guardian ad litem perpetually, because what she does is she acts as the court's eyes and ears on all 2,000 plus of our open cases, with picking cases at random. That allows her not to have an agenda or focus on one person, but to literally be able at any given time to investigate and help us do our duty as the overseer or our oversight duty in the ongoing conservatorship cases. So, and I do, by the way, she's got a test. If anybody hasn't ever taken the test, I've actually taken it and I passed, which tells you the bar wasn't too high on the test. But it's a what, 5 questions, Amy? 5 or 10 questions in there that you got to answer?
Well, it's 4 separate tests of 10 questions. It's 40 questions.
Yeah, I've in my memory, I've made that list questions. But in any event, if you have some free time and you're not even involved in a conservatorship case, it is very enlightening to go in and take a look at the test that Amy has set up. I feel like you'll probably pass it, but you might be amazed at the things you don't know, like the word fiduciary. You know, what does that mean even? If you go in and you look at the duties and responsibilities of a conservator, as Michelle pointed out, read those things over, take those tests that Amy's got, which we recommend to everyone now who's being appointed by our court. I think you'll find that, you know, it's not rocket science, but it really does bring to a sound reality what it is to be a conservator. So, you know, that's about all I got to say on that subject.
Amy, here's a question. Are there other tools that families can consider if they have a family member who's declining and they're worried that they might need a conservatorship?
That's a very good question, Barbara, and I get it quite often. There are several tools that an individual can use aside from a conservatorship. I think there's a misconception that an individual under conservatorship may be able to use another tool. So I'll expound upon that and then I'll tell you the other tools. So in order to, for the judge to provide an order that a person's under conservatorship, the judge has to determine by clear and convincing evidence that that individual has a disability or an incapacity. And so the other tools that can be used are for individuals who may have a disability, but they have some capacity whereby they can give someone else authority to make decisions for them. And so one of those things is a durable power of attorney that a person can use. They could use a durable power of attorney for healthcare. They can have a living will. They can also contract with individuals in order to make decisions for them or just assist them with financial planning or end of life planning or anything that they may need to make decisions for. But if a person lacks the capacity to make decisions for themselves or to appoint an individual, that's when a conservatorship comes into play, because that person just does not have the ability to either take care of their person or their property or both and make those decisions. And for the record, our office, if someone calls our office and the person is under has a power of attorney and they've been making decisions for that individual that may not be in the best interest of that person, our office does not help with that. You have to be under a conservatorship in order for our authority to kick in.
Here's a question for you, Michelle. Are there any organizations that will serve as conservator?
As I mentioned before, I represent the public guardianship program. So there are 9 programs throughout the state. There's guardianship and trust, there's ComCare, there's 50 Forward. There may be some other availability through the DIDS program if you have someone with intellectual disability, but those are the ones that come to mind in Middle Tennessee. And of course, the independent list that Amy maintains is a go-to as well.
Judge Kennedy, what are the specific safeguards that the court has to prevent financial exploitation?
Well, one of the most important functions that we're able to require to be performed in our court and throughout Tennessee in conservatorship law is we are allowed to require an accounting to be filed on an annual basis of all receipts and disbursements, all assets and liabilities. And oftentimes, if you attend one of our hearings, you'll hear me say from the bench in a ruling, I'll say, well, I order that you file a property management plan within 60 days, which includes an inventory of all assets and liabilities. And a property management plan is like a pro forma income and expense statement where you're projecting a budget for the respondent for the coming year or even thereafter. In addition to that, we'll say now, Mr. Smith, we're going to order that you also file an annual accounting. And the accounting, and these forms, by the way, are all on the website, the probate court clerk's website. We have a property management plan document. We have an accounting document that reflects how you do, and doesn't give you all the how-tos, but it tells you what an accounting looks like and how one might prepare it. It's similar to those of us who still balance checking accounts. And by the way, Mrs. Kennedy balances ours. She's, after 52 years of being married, she told me that I was not the competent one to handle our checking account. And I actually agreed with her with that. But if you can balance your checking account, you can do an accounting. And we require the conservators to file annual accountings of all receipts and all disbursements. That accounting is reviewed by the probate master, and a copy of it is sent to all, by definition, interested parties. That means the conservatee, the respondent, the interested family members, if they were parties to the case. And so if anyone has an objection to an accounting, or if anybody sees an expenditure that they think is inappropriate, then looking at that accounting will allow us to set a hearing. And that hearing may result in the removal of the conservator or some admonishment or other penalty. So accountings, property management plans, the bond that we talked about, all of those are safeguards. And then finally, also is the ability, of course, for me to sign an order, an at random order, of which I sign about 50 of them, I think 50 a month, every a month, that goes to Amy's office that allows her to launch, as a result of a standing order that we have in 20th Judicial District, that allows her to launch her investigation randomly with those 50 at a time. And I don't think you're doing over 50 at a time, Amy. If I am, we're overworking you if we are, but I know she's able to do that. She's able to reach out every month to a new set of conservatorships to see whether or not they are in fact doing what they should be doing. Also, by state law, and this is something we never waive, even if we were going to waive other things, is every conservator is required to file an annual status or an estate status report, letting the court know where the respondent is, where they're living, and how they're doing, and whether or not their disability has improved or diminished or gotten worse. They've got to do it every year. And so hopefully that's a way to keep people from falling through the cracks. That's one of our other safeguards.
Amy, here's a question for you. Suppose a family is concerned about a family member. How do they go about getting a conservatorship over their family member?
I get that call often as well. There are a number of ways an individual can do it. The one that we tell most people is to reach out to a probate lawyer or a state lawyer like yourself or Michelle in order to hire them to file the petition for conservatorship, which is required. And then the hearing before the judge takes place. And if the judge determines that that person does lack capacity or has a disability that renders them unable to make decisions, then an order is given that an individual, either the person who filed the petition or someone else, can be appointed to be conservator. Our office has partnered with the Tennessee Bar Association and legal aid societies across the state to put together a pro bono conservatorship initiative. Within that initiative, we target individuals between the ages of 18 and 22 who are in public school and who will require a conservatorship, but their parents may not be able to afford legal counsel for that. And there's a screening that is done in our office to make sure that that case appears to be categorically eligible for conservatorship. And then the Legal Aid Society will do a financial determination to make sure that that person is financially eligible. If that happens, then a lawyer from the community is paired with that family to help them file the petition at no legal cost to them, so that they are able to get the conservatorship for their disabled adult child. Otherwise, in Davidson County, an individual can file the petition themselves. There are some forms that legal aid societies have put together that individuals can use to file that petition. I typically encourage people to consult legal counsel because it is a difficult process for a person to do without any type of legal help. But that option is available in Davidson County if they can figure out how to file a petition on their own. Our office does not help people establish conservatorships, but through that pro bono conservatorship initiative.
Michelle, what if it's an emergency? What then?
Well, you can file an emergency petition without medical evidence. You know, most of us don't like to do that. We prefer to have that reported physician that's been filed by a physician that has treated the person, that the respondent, within the last 90 days. But there are emergency procedures in place. You can ask for an emergency conservatorship. If you do that, then the respondent has to be served with the petition within 48 hours, and there has to be a review hearing within 5 days. If you file an emergency petition, then you're going to get the appointment of an attorney ad litem. That is an attorney who represents the respondent. That is different from the guardian ad litem, who basically investigates the case and is the eyes and ears of the court. Under some circumstances, there's also a guardian ad litem appointed. That is not the normal procedure, but you can also ask for guardian ad litem. Those cases are now mostly being heard by Judge Amanda McClendon. She took those cases over some time ago to relieve Judge Kennedy's docket because Judge Kennedy had so many cases. And those appointments are only good for 60 days. They are void absolutely within 60 days if there is not a final hearing appointing a conservator. And if those time periods are not followed, those 48 hours and those 5 days, those are not discretionary. Those are mandatory time periods. Now, those are sometimes expanded upon if we fall into a weekend or a holiday.
Touch on something that Judge Kennedy said.
I'm sorry, Amy.
I said, can I touch on something that Judge Kennedy said?
Yes, please.
Okay, so what Judge Kennedy mentioned, the property management plans and the inventories, our office reviews all of those. But since the individual, the fiduciary supplies that information to the probate court clerk's office, our office gets financial information from the financial institutions directly. So we review all of the checking account statements or the investment account statements, leases, or anything that is detailed within the property management plan. We take a look at it firsthand. So if there's jewelry that's mentioned or fur coats or something that's in the property management plan, we will go out and look to make sure that information, or make sure those assets are still there. And we also look at the property to make sure that it's still there or still being kept up, because the information provided to the clerk's office is just based on the word of the fiduciary. So we just take it another step further. Oh, and to answer your question, Judge Kennedy, we probably have more than 50 cases all going at one time, but not for the person, but we review every case that has accountings every single year. And there are 260 of those in Davidson County. And so we're constantly reviewing those on an ongoing cycle.
And if I might add, Barbara, some of the ones that Amy does, and I didn't touch on it earlier, are really subject to audit. Not only does Amy's office look at the financial accounts, but occasionally she will conduct a complete audit of those matters to determine whether or not there's some transactions going on that maybe are not being reported in the accounting, which unfortunately could occur. So it's a great program.
Barbara, can I
Yeah,
touch on the emergency again? I filed one recently. I just kind of wanted to bring this to everyone's attention. I had to file it because there was real property that was being foreclosed upon. And the respondent's son had a power of attorney. However, it did not give him authority to sell real property. So we were not able to close the sale of the property. So if you're preparing POAs, make sure they convey all the powers that might be necessary, because the whole purpose of the POA is to avoid a conservatorship. But in that instance, we had to file for an emergency because we had a closing, we had to get this closed before the sale date. So just take a look at those, because that's very important.
So
If I might add, Barbara, also, I'd be remiss if I didn't mention this. When you were talking about emergency conservatorships, and Michelle's exactly right, Judge Amanda McClendon in Second Circuit Court was gracious enough to accept the transfer of all new emergency conservatorships that might be filed under the emergency conservatorship statute or the expedited limited healthcare fiduciary statute, which was also enacted. These statutes were enacted a couple of years ago. We were doing approximately 250 of these a year on top of the other 2,000 cases that we were doing. And so she took all of the new emergency cases, has had them, I want to say, gosh, it's been almost a year now, I believe, that she's been conducting those hearings. And when an emergency case converts, and Michelle mentioned this, that you got to do something within 60 days. Generally speaking, Judge McClendon will either keep the case and go ahead and convert it, or she can remand it or transfer it back to me, which often happens as well, when it becomes a traditional conservatorship. I'd also mention to you that emergency conservatorships are incredibly time sensitive, as Michelle pointed out. And you talk about a case where someone ought not to be their own lawyer. That's probably an area where the skill of a veteran litigator who handles conservatorships like yourselves, like you, Barbara and Michelle, really need to be a part of the case.
And Barbara, a lot of calls I get, I don't think it's an emergency. I will just tell the client, we just need to go the traditional route. In that instance, there was a foreclosure pending, but unless it's extreme financial abuse or placement issue, or someone's going to be homeless, usually they can wait. Now, the emergency limited healthcare proceedings, those are typically filed by a healthcare facility, because they have a client in the hospital, a patient that they are not able to safely place in the community, and they're not able to find any family members that can assist in placement. So those are a whole nother animal, and those are being heard by Judge McClendon at this time as well.
Right.
So Judge, we've talked about the guardian ad litem, who is the eyes and ears of the court, and the attorney ad litem. How are those roles different, and can you waive those requirements?
There are some cases where I don't have the authority to waive. In the emergency cases, you always, one of the things we all kind of learned in law school, when you look at those little green books, as we say, those Tennessee Code annotated statutes, you look to see whether or not the statute mentions the word shall. And in the emergency statute, for example, there's a shall on the appointment of an attorney ad litem on the emergency cases. An attorney ad litem, of course, as Michelle pointed out, is really counsel or representing the respondent. They are there to represent the manifest best interests of the respondent and to advocate on their behalf. And so what happens in many cases, not just emergency cases, but even in traditional cases, you will have a respondent. Let's take a non-emergency case, for example. Maybe you've got an 85-year-old grandpa, and grandpa's got some problems, but he's always thought of himself as the patriarch of the family, and he's pretty much had his own way about everything he did in his life, as we all would hope we could. But now he's suffering from some dementia, and that dementia is really causing him to act inappropriately and to do things that the family knows he would not do. So they file a petition. The family files a petition. They may even have a doctor's report already that says, grandpa's got dementia, and the dementia is interfering with his abilities to make financial decisions and executive decisions and activities of daily life even. But he's got just enough capacity to say to the judge or to the family, and I'll put this in quotes, hell no, I don't need a conservator, close quotes. And so what do? Well, we have a statutory obligation. We shall appoint an attorney to represent him in his defense against the appointment. And if he has any valid defenses, if he has any valid reason other than he just doesn't want anybody else to tell him what to do, that he can present to the court. And for example, if he says, I don't want my son to be appointed. I don't trust my son, Bobby, or I don't trust my daughter, Susie. If that's the case, then that attorney ad litem is there to advocate on behalf of our 80-plus-year-old grandpa, his position that person shouldn't be appointed, and that maybe someone else from the panel or one of these agencies or some other family member perhaps should be appointed. So the attorney ad litem is more of an advocate and is in fact responding on behalf of, similarly to what a defense lawyer would do if one were appointed in a criminal defense case. Similarly, but not exactly the same.
Amy, what if somebody says, I've had a traumatic brain injury, but I've recovered, I don't need a conservator anymore. How does that happen?
We get those calls all the time as well. I've gotten a few in the past couple of weeks. And what happens in those cases is I will speak with the person that's under conservatorship, find out what reasons it is they think they no longer need a conservator. And I will also explain to them that their physician will need to complete the physician report form that the clerk's office has in order for them to be relieved of that conservatorship or for that conservatorship to be terminated. What happens in that case, I also contact the conservator to get their take on it and to talk to them about the case. And then our office simultaneously files a report with the court, alerting the court that the person would like to have a hearing on their disability and they've determined that they no longer need one. In many of the cases, in about half of the cases, the person has been relieved from their conservatorship and those conservatorships have been terminated. In those cases, the person has now resumed working and they're taking care of their own, all of their own responsibilities anyway. The conservatorship was just continuing because the conservator didn't come back to court to terminate it. And in other instances, the person has made many improvements. However, they have not made enough improvements in order for their conservatorship to be terminated. And many times Judge Kennedy will give them back many of the decision-making powers for themselves that they're able to make for themselves. And then that conservator will have a limited conservatorship where they're only making certain decisions, whether they be medical decisions or decisions with regard to where that person, helping that person find housing or continue to sign contracts for them, but he will allow that individual to resume driving or have employment and go to school and just whatever things that they're able to do, those are tailored to that individual person.
Michelle, suppose I have an elderly neighbor and I suspect that she's being financially exploited. What should I do?
I generally tell people you can call for a welfare check, as Amy mentioned. I also tell them they can call Adult Protective Services. That is always a confidential call. I usually tell someone to, if you can get in the house and you can look for signs of, is there any physical abuse? Is there food in the house? Sometimes oftentimes they're being exploited by their own children. I mean, that's a great majority of the time, unfortunately. That's what we see. So you may have a family member that's literally taking mom or dad's only source of income, which might be their Social Security. You know, I always say, look around, see if you can see, do they have medications, you know, art, if, you know, without being too intrusive, but if it's your next door neighbor and it's someone you know, can you see the date on food or can you see the date on medication? And, you know, make that call to APS because it's always going to remain confidential. They never give out their informant. I've seen an informant in public records that the person that's called from APS to testify would not even release. You know, they never give out that information. So those are two tools. You know, otherwise there's not a whole lot else you can do. You know, you can try to contact a family member if you know it's a good family member. And, you know, then I tell them, yes, you can file a petition for conservatorship. You know, anybody can. And, you know, we discuss what that looks like and what the responsibilities are. And, you know, if it's just your neighbor, you know, you may not want to get involved in that level of care. But I do tell them make a welfare call or call APS. You know.
Judge Kennedy, there's a whole list of powers that can be removed from the respondent or the ward, the person who's the subject of the conservatorship. Do you sometimes let the respondent keep some of those powers?
We do.
Which ones are you most likely to let the respondent keep?
Yeah, the one that comes to mind, that leaps out at me. Actually, there's actually three that kind of leap out at me. But when I first became a judge back in 2003, one of the ones that I used to see as a standard removal in almost every proposed order from every lawyer was the removal of the right to vote. And it really caught me the wrong way. And I tell this story to a lot of people. I can remember back when I was a young man, a very young man, working the polls in another person's election, and they brought a fellow in on a stretcher who was a quadriplegic, but who had his mental faculties about him, and the privilege of voting was the most important thing to him, I suppose, in the most appropriate social activity he could engage in. And I always felt great that he was able to get in there and cast his ballot, even though he had to have someone else pull the switch to vote, which is a difficult challenge too. So I didn't like the idea of removing the right to vote unless the person's capacity was literally so significant and substantial that they couldn't even make a decision. It's so precious as the electing to vote for somebody or against somebody. The second one was the ability to communicate with, visit with, and interact by mail or phone with other people. And the first time I ever got involved in that one in a big case was involved in the Glenn Campbell case, which I think someone has asked us about earlier today. And while I can't comment on the merits or any matters that might still remain pending in that or any other case, the legislature ultimately passed an act which they named the Peter Falk Glenn Campbell Act. Why Peter Falk? Peter Falk, of course, was Columbo. And the allegation was that Columbo, Peter Falk, who had advanced dementia prior to his death, and I believe had suffered a series of strokes, if I'm not mistaken, that one of his lady friends and or spouse was denying him interaction with his own family. Likewise, there was an allegation that Mrs. Campbell was doing this with regard to Glenn Campbell. Now, the court record will reflect that I made a finding that that was not true, that the children of Glenn Campbell never were refused the opportunity to meet with their dad. Nevertheless, the legislature passed this thing called the Falk-Campbell Act. And if you look at our enumerated powers, Barbara, as you oftentimes do, there are about 16 of those that are enumerated. And one of those involves that ability to communicate with, speak with, talk to, interact with other people. I'm very reluctant to pull the trigger on removing that right from anybody. I usually, even in contested cases, and Michelle's been in a few of them as well where I've done this, I look at the family at the end of the trial oftentimes where they've been battling each other over who ought to be in charge of taking care of grandmother or Aunt Susie on her in her declining years. And my position is, would Aunt Susie really want to be denied interaction with any of her children, with any of her nieces and nephews? Well, maybe there might be a reason to call somebody out, some ne'er-do-well scallywag, but otherwise, in the absence of that kind of evidence, I want that right to remain with the individual. The other rights are ones that Amy touched upon. I recently had a young man who worked at one of the local grocery stores. He was able to maintain a little bank account. He was going to work 4 and 5 days a week. He loved to go to church. He was involved in his church. And yes, he had a significant developmental delay that made his abilities to do executive decision making somewhat limited. But I only transferred the power to contract, you know, the power to fire a doctor if you needed to fire one, those kind of things that you normally say. I did appoint a conservator over both person and property, but I can limit, all judges can limit, and should, by the way, according to the Supreme Court, should make the least restrictive parameters or guardrails that you can and still be able to protect the individual. So in that young man's case, if I recall correctly, I think we probably transferred maybe 6 or 7 of those 16 powers and modified those to make them very limited. I mean, freedom, we don't want to lose sight of this. The freedom of that disabled adult is still important. And the case law says that we must do what's in the manifest best interest of the respondent. So that's how you get there.
Well, we have one more question, and I think this might be an important one. Who pays? Who pays for this? Does it come from the family? Does it come from the person who's the ward? Yeah.
If I can touch on that, and I deal with that every week. Every Friday we have a motion docket, and during the week we have cases oftentimes that battle over who should pay what. Generally speaking, there's a statute that says if you appoint a guardian ad litem, and if the case results in the appointment of a conservator, then the guardian ad litem's fees shall be paid by the respondent. In other words, you've got a disabled respondent, and Amy sees these and Michelle sees these as well. And oftentimes the respondent doesn't have any money or doesn't have any funds. That doesn't prohibit the petitioner who filed it, you know, the children or the parents or other people from paying the guardian ad litem's fees. But I will tell you that oftentimes our attorneys in Nashville, and I know both of you, I know all of you have done this, will elect to take CLE credit or hours of continuing legal education credit in lieu of a fee, or they'll do it pro bono. In the absence of that, the respondent pays the guardian ad litem. Now, if I have a case that's controversial and where everybody's hiring a lawyer, and who pays the lawyers? Let's say the children have hired dueling advocates. Okay, we've got the brothers hired a lawyer, the sisters hired a lawyer. They're both fighting over who should be in charge of their loved one's affairs. Oftentimes, I'll require them to pay their own attorney's fees, and that is discretionary. And all of it, by the way, is subject to 3 things. It's subject to the rules of professional conduct for lawyers. It's subject to the local rule of court that we have, Local Rule 39. That's our local rules of courts. And it's subject to case law that the fees should be both reasonable and necessary. And so we require people to file time records and affidavits. And if there's a contest, we'll have a hearing. If there's not, we will scrutinize their request and hopefully tax those fees to the appropriate person.
Well, thank you so much, Judge. Thank you, Amy. Thank you, Michelle, so much for your expertise. I often tell people that I'm planning to be ornery and demented someday. So it's really good to know that the court is out there. I just want to say the court, Michelle, the Office of Conservatorship Management, they function amazingly well in Davidson County. It's really such a tribute to all of you. So thank you everyone for attending, and we will see you at the next program.
Bye.
Thank you, Barbara.
Thank you, Barbara.
Thank you, Barbara.
Thank you.